Welcome to the SARE Ladies Podcast, where our mission is to get more people that look like us participating in the real estate industry.
Whether you're a seasoned real estate pro or just starting out, there's something for everyone here.
I'm Anita Wong.
And I'm Tiffany Lee.
We invite experts to not just talk about real estate, but also about our unique identity as Asian women and the cultural values that shape who we are as investors.
Now let's get on with the show.
Welcome back to another exciting episode of the SARE Ladies Podcast. I'm Anita Wong.
And I'm Tiffany Lee. We're so glad you're joining us today for what will surely be an incredibly educational and fun episode.
Today we have on our pod Bridget Eichinger, who is an attorney with the esteemed law firm of Falcon Rappaport and Berkman. Bridget focuses her practice in the area of estate planning, estate administration, and elder law.
Bridget's work is incredibly important as many, especially in our Asian community, want to know how to protect our loved ones in a tax-efficient manner. I think coming up from an Asian upbringing, honoring and taking care of our family is such a big part of our identity. But we also hate talking about aging, sickness, and death. The underlying reality, it's okay, I'll cut this part. The underlying reality, though, is we want to make sure our families are taken care of no matter what happens to us. With that said, welcome to the pod, Bridget.
Well, thank you. Thank you for having me, Anita and Tiffany. I'm glad to be here.
Amazing. Bridget, tell us more about you and what sparked your interest in estate planning and elder law.
So I have been an attorney since 2007. I became interested in estate planning and elder law by working as an attorney in a small practice where they were creating wills and trusts and powers of attorney for people. And I got to see how practical it was. And it's really one of the nicest areas of law because people are planning for their families. They're trying to take care of their loved ones. And it's something that's useful for everyone. People come to you with real goals and real problems. And it's really nice to be able to say, okay, I know how to fix that. You know, they have a child with special needs. I can help them with a supplemental needs trust. They are worried about losing capacity. Maybe they have dementia in the beginning stages. I can help them with powers of attorney. They maybe have a second marriage and they want to make sure their children from their first marriage are protected. I can help them with that. So it's one of the most practical areas of estate planning and something that is helpful to everyone. And it's a really nice field because you get to help clients make their last gifts for their loved ones.
That's a great segue to, obviously there is an immediate need for, those who are in the later stages of their life and maybe people who already have children. But what about if you're at a dinner party and someone younger, maybe in their 20s and 30s who have just started earning? Is that something that they should consider? Like, what if they ask you, why do I even need an estate plan? I don't even have a family. I'm not married yet, or even they're about to get married. What is your general go-to answer for someone who's in their 20s and 30s?
Right. I mean, really, realistically, everyone over the age of 18 should at least have a power of attorney and healthcare documents, especially if you're not married. If you are in the hospital and unable to make a medical decision, who do you want to make that decision for you? You'd want it to be the person that you chose. So having healthcare documents becomes very important, especially maybe if it's a significant other that is not someone your family likes very much. It would be good if you had a healthcare proxy saying they're your primary agent. Otherwise, the doctors won't talk to them. For power of attorney, anything could happen to any of us at any time. So if you lose capacity and the accounts are just in your name because you're single, no one can access those accounts, even if it's for your care. If you need extended care and somebody has to pay your rent and keep your utilities on so your pipes don't freeze, no one can access that money if you're incapacitated. So it becomes even more important to have an agent named. I'd also say for people with small children, there are laws regarding intestacy in the various states, which means if you don't have a will in place, who is going to inherit if you die. And I practice in New York State, and in New York, if you pass away with no will for any asset that's not jointly owned, the first 50,000 and half of everything goes to your spouse, and the other half goes to your children. And that's not a good result if your children are 2 and 3 years old. So it's really important for young couples with young children to get their documents in place.
This might be an ignorant question on my part, but why would that divvy up not be a good outcome for small children?
So obviously the surviving spouse is probably going to need that money, and you'd want the surviving spouse to be the one making decisions about what the money can be spent on and what they're going to do with it. The 2 and 3-year-old aren't legally able to own property. You have to be in New York 18 years old to own property. So it's going to end up in an account that's supervised by an attorney appointed by the court. It's not going to be someone your spouse selected. It's just going to be somebody on a list that the court keeps who's willing to do that kind of work. And you're going to have to go to that attorney every time you need money for the children. And then when they're 18, say it was a lot of money, they just get the money at that point, which most 18-year-olds aren't ready to manage large amounts of assets when they're 18.
That makes a lot of sense. So, yeah, so I guess it's like considering all these like potential loopholes. Like we were talking before we started recording the podcast. You said that attorneys are inherently more anxious than other people because you're anticipating all these potential worst case scenarios. So I guess we can get sidetracked a little bit. What has been a worst case scenario that you have seen blown up? Don't have to mention any names, but we can talk in the abstract of someone who didn't estate plan and think ahead and something had happened to them. And this is like the nightmare story. Let's hear what that has been.
Right. I mean, I've seen a few different things. I've seen, someone who's not a minor, an adult, and a very competent adult, but but a youngish adult, and her dad passed away and there was no will. So the mom when there's no will, you're not the executor, that you're the administrator. You apply to court to become the administrator. And so the mom was administering the dad's estate and trying to gather assets. And before she finished, she passed away with no will. So then this poor person in her 20s who's grieving the loss of both her parents is trying to manage administering both her parents' estates. And that's hard. It's emotionally and logistically difficult and time consuming. She was a student, so she was trying to take her classes, grieve, and handle 2 estates, where it really would have been ideal if the parents had picked someone to serve as their executor that could have actually taken care of the young person, as opposed to the young person now being saddled with all this responsibility. I had another estate years ago where the person who passed away had a will that was originally prepared in an attorney's office, and he had millions of dollars, but he was very frugal. And when he wanted changes to his will, he didn't go back to an attorney at a law office. He went to his friend who was an attorney, but not a practicing attorney. And the friend created a codicil. And then over the years, he did that 3 more times. So he had a friend who created a codicil, then another codicil, then another codicil. So now you have 4 documents. And every time you create a codicil, not only does the original will have to be submitted to the surrogates court and approved by the surrogates court, but so do the 3 other codicils. So it's almost like probating 4 wills, and each of them has to be executed correctly. The first one was good, but none of the codicils had what we call in New York a self-proving affidavit on the back. And a self-proving affidavit is the witness is swearing in front of a notary that they saw you sign your will, nobody made you sign it, you appeared to be of sound mind over the age of 18, and a few other things. And so if the people sign this in front of a notary within 30 days of you signing your will, when you pass away, the witness don't have to be located. They don't have to testify in court. They don't have to sign an affidavit. It's a self-proving affidavit and you're all set. Of course, none of the codicils had the self-proving affidavit. So we needed to locate all of these witnesses, which each codicil, it was different people, some of them deceased, some of them, like in order to do it, I had to contact people, send certified letters. There was actually a couple of the documents were witnessed by a doorman and an office manager at their building in Manhattan, at the decedent's building in Manhattan, and you know, not everybody wants to get involved. Not everybody likes the beneficiary. And even though the entire family was in agreement and all the beneficiaries were okay with what the documents said, the court wouldn't accept the documents until we had all of our affidavits signed. And the other issue in this case was the original will was lost, along with everything except the third codicil. And in New York State, if the will is lost, the court presumes that the person who created it intentionally destroyed it. So because the court's job is to make sure the wishes of the decedent are honored. So it involves submitting a lot of affidavits and things explaining exactly the chain of custody of where the will was stored, what happened to it, why we know that the person did not intend to destroy it. And it just really dragged out the probate proceeding for years and made it really expensive for the family.
That totally resonates with me because I am literally dealing with this issue where my aunt has, my cousin has lost the will. So I was like, oh yes, it makes a lot of sense. Like the court will consider that, they intentionally destroyed the will, even though she was, sick for a very long time. And I was like, why didn't you just find the will? Why would like she was, so anyway, that's interesting. So I want to kind of circle to, since this is about challenges, really, I kind of want to hear about what are some challenges that you see, especially with immigrant families, and what are some ways that you might suggest to mitigate risks, especially for them, these population?
So immigrant families, there's a couple of things that could make it a little more complicated. One is if you own assets in another country. So if I have clients, I can only advise them on New York law. I don't know the law in the country that they came from, and clients, they like to just get things done. So they want their New York will and they want to move on with their life. But really what you should be doing if you have real estate or bank accounts in another country is making sure you check in with an attorney in that country, and probably you need a will in that country prepared by an attorney licensed there to say what happens to those assets when you die, and also a power of attorney in case you were to lose capacity, so someone in your family or someone you trust can access the assets and use it. Sometimes people think it's simple and that it just happens automatically in this. I've heard this about one country, and then recently, and then I had just a networking meeting with an attorney in that country recently, and she told me, oh, that's what the law says, but it takes families years to actually acquire the assets in that way. And I really recommend that they get a will done and that it gets registered in the courts here, and that's what's going to make it easier for their families. So I was so glad I met with her, because at least now I have some authority to say, Oh no, I've consulted with an attorney from this country, and and she told me that it really is difficult for families if they don't have their documents in place there.
Mm.
The
I
other
also,
thing, oh,
Mhm.
sorry.
No, I was gonna touch base on like something that you said earlier about a client being frugal. I'm looking at you, Dad. You know? I definitely hear, like, I mean, my dad was doing TurboTax, or I mean, he will die on that hill. He would rather do everything himself, be frugal, and sort of there are some growing pains with that, especially when you're having your, like the guy who lives in your building do your legal work, right, as a friend, So, um, is that something you kind of deal with often, I guess?
Yeah, it depends on the client, and their personality and what they do. But I mean, if I have a plumbing problem, I hire a plumber because they know what they're doing. I'm probably going to create a mess if I try to do it myself. And certain clients, like some clients will look at the estate planning documents and they'll say it's so complicated. I want it simple. I want my son to be able to read it and just do everything it says in here, and he's not going to know what this part means, right? Because they don't like our boilerplate. But our boilerplate was developed very carefully because it provides for a lot of things that the client isn't necessarily going to think of, right? They haven't been to law school. It applies to every situation that could ever arise that could cause the family problems. And if it doesn't cause them problem, if that's not the case when the person dies, that's fine. It won't hurt anything. But good thing that provision was in there just in case this potential problem arose. So a lot of times clients are kind of do-it-yourselfers and they want it to be ridiculously simple. But it's not. Like, things are complicated, the law is complicated, and it's better to have all the provisions you need in case they're needed. And I can say a bad will is worse than no will, right? So if it's a will that complicates things, or it has a missing page, or it refers to the wrong article number at the wrong time, it's actually harder to show the court that's not what they meant. They actually meant this. Than it is, at least if there is no will, and you have spouse and kids, it is ending up with spouse and kids. So I do think it's a worthwhile expense. You work so hard your whole life to acquire the wealth that you should try to make sure that it ends up where you want it to end up.
So, question here: if you don't have a spouse or kids, and you don't have a will in place, then how does that domino effect?
Right. So
Asking for a friend.
it depends on your state. It depends on your state. A lot of people think it automatically goes to the state. There's like a long line of people named in New York state law. Like, it would go to your parents. If your parents weren't alive, it would go to your siblings. But if any sibling was predeceased, it would go to their children. Then if there were none of those people around, it would go to your cousins. So like, there's a whole line, and only when the whole line of people, if they're all predeceased, then it would go to the state.
So it goes to like nephews and nieces first before it goes to cousins. It's like just
Right.
like okay.
Right. In New York.
Okay.
Mhm.
What if there's like illegitimate children that you don't know of until you do like a 23andMe?
Right. So that's another good reason to have a will, right? Is because you could say in it, but my children are and I've done this for people because there has been some doubt at times where I've said, you define who the family members are. These are my children. My intention is that the only people to benefit under this instrument are these people I'm naming and their descendants, and no one else. So you can do that. You don't have to leave your assets to all of your children. You can pick and choose.
Yeah, that's what I have in my will too. My husband is not allowed to give like children from his second marriage. It's like my money, so it's in my will to also put that. It's not specified. Apparently, it's like you have to be really specific about that. So that was really
Anita,
interesting
did you
learning.
just say second marriage? What about a third marriage?
Yeah.
Just any
No, no, no.
subsequent marriage? You're like, just this
Absolutely
one
not.
loophole, third one's okay.
Right, that's why you create trust within your documents, right? You can give money to your spouse to be held in trust that they can use it during their lifetime for themselves or the kids, but then when they pass away, it has to go to your children and they can't redirect it anywhere because life is long. You know, if I pass away soon, I hope my spouse remarries, but I hope my assets end up with my kids.
Yeah, I was very specific about my husband. Like, absolutely not.
Anita, was this the thing that happened? Like this thought occurred to you after your daughter was born? You're like, actually, wait a second. It's like, oh, it was?
Yes. Well, I think like everyone when they reach a milestone, they're thinking about these things, right? Bridget, you're like, all my clients come after they get their first kid or they get,
Exactly.
right? So it's like that. So we actually did everything at that time because we did have wills. My first will was actually during COVID because I thought we were gonna die, and but then afterwards I was like, oh, this is not applicable anymore once you start having kids, and so everything had to be rewritten, properly with the lawyer and stuff. So, wow.
Right. That's the impetus for a lot of people. Some people, they get married and they get their documents, or some people have a health event and then they get their documents in place, or even sometimes it's just going on a trip. We're going on a trip overseas and we're worried, what if something happens to both of us?
Yeah. Every time someone worries, a lawyer gets paid. That's
Right. You hire the lawyer to worry for you,
yes.
and even think of things to worry about that you didn't even realize you had to worry about.
They're my anxiety ShamWell. Like,
yeah. Every time I call a lawyer, I'm like, please make this go away. Like, I don't want to think about this anymore.
Okay, so I have some questions about I think what I've always been super interested is how the ultra wealthy really manage their estate planning. So my question is really about if you're from clients from different socioeconomic backgrounds, in particular, how do you see the middle class versus the ultra wealthy approach their estate planning?
I mean, it depends. There's different personalities within any socioeconomic group. I think more often the wealthier clients, if we wanted to generalize, would understand that this is just an expense. This is something I've just got to get done. And they just see it just like I go for my annual physical, I'm going to get my estate planning documents in place. Where I think maybe the middle class is more do-it-yourselfers, where they're hoping they can just find a form online, or they can go to their family friend who's a real estate attorney or their personal injury attorney and just get a will prepared by them. Whereas I think maybe the wealthier clients say, okay, I'm going to an attorney that practices exclusively in this area, and they expect it to be a little more complicated, right? They want to see, like, what are some options? This is the issue I see. What are some pros and cons of creating this trust that you're suggesting? What are some choices? Where I think, maybe the more middle class thinks, I can figure that I'm smart. I figure out all this other stuff. Let me just figure out how to do this easily and use the most reasonably priced attorney I can find to do something called a will, right? They say, I did it, I got my will. But sometimes it really is, you get what you pay for. And the attorney that concentrates in that area and maybe charges a little more might be able to keep abreast of the law in that particular area, because they're not also trying to sell real estate or manage personal injury lawsuits at the same time as drafting wills.
So I have a question. Go ahead.
Oh, I was going to ask, how would you vet a estate attorney? Like, what qualities would you look for to differentiate what you think would be a good one versus a bad one?
I mean, the easiest way I think is look on the website and see what their practice areas are. And if they're practicing in 12 different areas of law, chances are, they might not be as well versed as someone who practices just in estate planning and elder law. Word of mouth is always great. Like if you know anyone who went to that attorney, they can tell you about their experience with them. I think picking an estate planning attorney is sensitive because you're not only creating the estate plan, but that person generally stores your original documents for you because you don't want the court to think your will was intentionally destroyed. So you have the attorney hold on to the documents for you. So it's probably the first stop your kids or your family members are going to make after you pass away. So you want to pick someone that you're comfortable talking to and that you'd be comfortable with your family members going to for guidance after you've passed away. You want to send them to someone that they're comfortable dealing with. You also want it to be someone you're comfortable dealing with. All the time I have clients who had beautiful trusts prepared at other firms, and they bring them in these beautiful binders, and they're these big thick trusts with all these provisions, and they really are well done. But then I say, well, what's in this trust? And the client says, what do you mean? Right? There's no assets in the trust. Nobody ever retitled anything to the trust. It's just an empty vessel that's sitting there unused. So, and the client doesn't even want to talk to the attorney who created them. They kind of, they're not comfortable talking to the attorney who created the documents.
What happens if the
I've heard
attorney
from.
dies?
Sorry, say that again.
What happens if the attorney dies that was supposed to manage the trust? Like, what if everyone who was supposed to manage it is dead? What happens?
Right. So if the attorney is gone, they're not that those documents are the property of the client who hired their attorney to create them. So there has to be someone hopefully the attorney made plans before they passed, but even if not, the executor for the attorney who passed away should be contacting the former clients and saying, I have your documents sitting in our office. Do you want to keep them? If we don't hear from you, we're sending them to this other law firm for storage. But if you want them, please contact us. So it's really the responsibility of the attorney's estate to make sure that the documents end up either stored at another law firm or back with the family member who was chosen as the executor.
Got it.
I had a back thought about one of our other friends who was on this podcast who said that you can't measure a lawyer by how much trouble they've been in, because it just is the more trouble they have been in, the better lawyers that actually they are. So you can't really count on the reviews all the time. Do you think that's true?
Well, I mean, it definitely could be. Not everything is simple. People want things to be simple, but sometimes things are complicated. And especially if you're administering estates, you can only deal with the documents that were originally created. And if your firm didn't create them and they were created somewhere else and brought to you by the family members of the decedent, then you're kind of stuck with them and you have to deal with what you can. And families, if your family doesn't get along, that creates more complications. So it can be, it really can be dependent on you and your family regarding how smoothly things go. But it should be that you're comfortable talking to your attorney and you don't mind doing that.
So I think what's interesting that I found out was that most companies have legal insurance. So they actually do provide you free services to do wills, right? Just maybe very simple ones. How do you advise on people that can do that? And then when should they, maybe find someone that is more specialized, but in their own I guess a lot of people in our listeners have portfolios of real estate. Should they be using very simple wills that are, basically provided by, insurance, by legal insurance, and will that cover them for their portfolios?
Right. And it depends what kinds of documents are created. I've seen, some of them. So I would say there's really no way to know for sure unless you bring your documents that were prepared for the discounted rate to an estate planning attorney to analyze and see, do these cover you, or do you need to get something else in place? Usually those documents are fairly short, and you think if they're doing it at the bulk rate and they're kind of churning out a large number of documents, there's a reason they can do it at the reduced rate. So are they really, the attorneys working for those companies, are they really able to spend the time on what your family actually needs? And do they really have the resources to create the best plan for you? And I would say, especially the power of attorney, people prepare those online, um, the power of attorney documents, or they have them done by an attorney that doesn't practice in estate planning and elder law. And I would say be especially concerned about the power of attorney document. In New York State, there is a statutory form for part of the document that gives certain powers to your agent. But there's different spots within that document to initial when you're signing it. And a lot of documents come in from other firms to our firm when a new client comes and says, can you review what I have in place? And either those documents are initialed in the wrong spot, they weren't notarized correctly. There was no gifting authority given, meaning if this person's in a pinch who's going, say the person loses capacity in the future and the family needs to get assets out of their name so they can qualify for Medicaid to cover their long-term care costs, they can't because there's no gifting authority in the document. The money can only be spent on them. So the only choice is to just spend all the money down till it's gone and then apply for Medicaid, as opposed to a power of attorney that adds some additional powers where your family can create a trust for you, gift your assets into that trust, and then apply for Medicaid to cover long-term care costs and have the health care covered. And then the money is there for that person's living expenses and for the family when that person passes away. So it's really limiting. So we end up with families where the parent has an insufficient power of attorney document, and then the children come in and they need a guardianship proceeding brought in the surrogates court because the parent no longer has capacity and the power of attorney document didn't do everything that it needed to do to provide for that person. So now it's a surrogates court proceeding, and that is a whole thing. It's a court proceeding. It's much more expensive than getting your estate planning documents done correctly, and it's also a bit traumatic for the family to go through that process, and it takes time. And there's no guarantee that the court is going to cooperate and grant guardianship.
So I guess let's turn the tables a little bit and talk about the inheriting side, because as often as children of immigrants, and we have parents who maybe spent many years in the back of a restaurant or a liquor store, and with really wanting to pass down the legacy to their kids. I want to kind of hear about what we need to know about inheriting and what should people be mindful of with their inheritance, or maybe some of the biggest challenges they've seen for people that are inheriting.
Okay, so if you're inheriting, really, it's great if your parents or your family members that you're inheriting from will let you get involved in their estate planning ahead of time. So that's kind of the best case scenario, is that you were involved before they passed away and you made sure their documents were okay so that everything would go smoothly, and maybe anyone inheriting under those documents gets any trusts or things they need in there. So like if you want to receive your assets in trust so that they're not considered part of your estate, so that when you pass away, you're not over the estate tax threshold, then it would be good to, make sure your parents are creating an ongoing trust for you. So that's, step one is, what do their documents look like? But if you didn't get to be involved in their documents, a lot of parents are very private. They don't want to share their information with their children. They did want to save money on their estate planning, so they just got it done quickly. Then you're kind of stuck with what you're receiving. And if you're receiving everything outright, I think step one is, if it's an asset that passes by beneficiary designation, say you now have an IRA that used to be your parents', make sure you change the benefit, or you put a beneficiary designation on there to say, this is who I want to inherit when I pass away. And then all your other assets you're acquiring, now it's time to do your own estate planning, especially since we're talking about real estate. If you're ending up with real estate in more than one state, that's when you're thinking, it would really be a good idea, instead of just having a will, maybe I should have a revocable living trust. Right? If you're passing real estate from another state to your beneficiaries when you die, that's as many probate proceedings as are states involved. So if there was a vacation place or a rental property in Delaware, and you pass away and you lived in California, that's a probate proceeding in California and an ancillary probate proceeding in Delaware. So that can get expensive and complicated. So for your own estate planning, you might want to create a revocable trust, get new deeds for all the real estate so that your trust owns the properties instead of you as an individual, or hopefully you have them in LLCs and you can assign the LLC interest to the revocable trust, or you can make the revocable trust the member of the LLC. And then when you pass away, your successor trustee just steps in. There's no court involvement. So you've avoided probate in the state you live in and in all the other states.
Got it. Okay. Well, I feel like I have a lot of work to do after this.
More ideas.
I know. Oh my gosh, there's more things to protect. But yes, I was like, I gotta talk to
Oh
my
man,
lawyer
Anita,
about
you've got out-of-state properties too. So
and out of country properties, yes. But
oh yeah,
yes,
you didn't even consider that in your puzzle. Did you? Look, you learned something new today.
I can't even read the contracts in the out of country. Like I can't even read them. I mean, and so I'm like, can I even find
you
a lawyer?
definitely need an attorney in that country. Oh,
Exactly.
the other thing I didn't mention to you when you asked about immigrants, if anyone's, if their spouse is not a U.S. citizen, if they're recent immigrants and say that, one person passes away and their spouse is not a U.S. citizen, you want the person who passed away to have a QDOT trust in their documents. You want a trust for the surviving spouse, because if you're U.S. citizens, there's an unlimited estate tax exemption between spouses, where when the first spouse dies, if it's your surviving spouse inheriting, there's no estate tax. Not true if your spouse isn't a U.S. citizen. You're only passing $60,000 to your spouse before there's estate taxes if they're not a U.S. citizen. So that's something definitely to go see an attorney about, where they can inherit and trust, and at least it delays estate taxes until they've passed away, which could be really important if there's investment properties that the surviving spouse is relying on the income during their lifetime. Because if they have to pay a huge estate tax bill as soon as the first spouse dies, and the only way to do that is sell the properties, there goes their income.
Interesting. I don't know why I thought like mail order brides really need to understand that.
Who are you?
Oh, wow. Okay. There's so much to think about. Thank you so much, Bridget, for being here and just answering so many complicated questions. And I feel like I feel like you would fit into our, our It Depends. We have this series where we just call it the It Depends series, where we have people come in and offer advice, but honestly, everyone just says it depends. So,
Which is usually true, right? If you really look at anything hard enough, it depends.
Thanks, Bridget, for being such a good sport. While we asked you, I feel like I asked you more silly questions. Anita had
I loved your questions. Thank you for having me. I thought they all brought up really good points.
And it was amazing having you here. If any of our listeners want to reach you, how can they best do that?
Okay, so you can reach me by email. I'm beichinger@frblaw.com, or you can call my office, 914-666-5600.
And disclaimer, you have to be in New York to... Yeah.
Well, actually, so I am licensed in New York, but we have people at my firm licensed in Connecticut, New Jersey, Florida, California. So we have a few different options for you, and I could certainly be your first point of contact if you want to call, and I can get you to the right person to help you.
Perfect. I'm glad we cleared that up. That was a throwaway message, but so if you're in any of those states, just hit up Bridget. She probably knows someone who knows someone that can help you. All right. Thanks for joining us, Bridget. Have a wonderful weekend. This was such a great chat. Appreciate it.
Oh, well, thank you.
Thanks for listening. But before you go, we've got a quick subtle Asian real estate update for you.
Hey, SARE Ladies listeners, have you heard about our upcoming Women's Summit? On July 25th and 26th, we are gathering in beautiful Costa Mesa, California, and you're invited. Imagine spending 2 days in a gorgeous house with fellow API female investors, diving deep into our personal development, leadership, and real estate strategies. This is your moment to shine, to learn, and to mastermind with the best. Don't miss this chance to connect, grow, and succeed together. Visit SareLadies.com to secure your spot today. Let's rise together, SARE Ladies. See you there.
The following is an important legal disclosure regarding the content of the SARE Ladies Podcast. Entertainment purposes only. The content provided in all episodes of the SARE Ladies Podcast, including discussions, opinions, interviews, and any other type of content, is intended solely for entertainment purposes. It should not be considered professional, financial, legal, or any other type of advice. No professional advice. The hosts, guests, and producers of the SARE Ladies Podcast are not professional advisors. The content provided should not be relied upon for making any personal, financial, or business decisions. We strongly encourage our listeners to seek advice from qualified professionals before making any decisions based on the content of this podcast. No liability. The creators, hosts, and producers of the SARE Ladies Podcast shall not be liable for any errors or omissions in the content provided, nor for any actions taken by any listener based on the information provided in the podcast. Any reliance you place on such information is therefore strictly at your own risk. No endorsement of investments. While we may discuss a range of topics, including investments and financial strategies, such discussions are for illustrative and entertainment purposes only. The SARE Ladies Podcast does not endorse or recommend any specific investments or financial products. Consult professionals. We strongly advise our listeners to consult with a qualified professional for advice tailored to their personal circumstances before making any investment or financial decisions. No association. There is no association between SARE Ladies and a guest speaker or professional. By listening to the SARE Ladies Podcast, you acknowledge and agree to this disclaimer and understand that the content provided is not intended to replace professional advice.
Now on to the show. Thank you for tuning in to the SARE Ladies Podcast, hosted by Anita Wong and Tiffany Lee.
If you enjoyed our show, please leave us a review or follow SARE Ladies on Spotify and Instagram. And also click on our show notes to subscribe to our newsletters to stay on top of our news and upcoming events. Until next time, Pod Squatters.